Hello friends, welcome to the Cases channel. This video contains the case of GE India by the Supreme Court. Section 195 has been dealt with in detail by the court in this case very well. The Transmission Corporation case has been misquoted by the officers normally. The answer to Transmission Corporation of AP Ltd is the GE India case in terms of clarity in the interpretation of Section 195 dealing with withholding of taxes from non-resident payments. Please like the video and subscribe to the channel. The questions that the Supreme Court seek to answer in this case are whether the High Court was right in holding that the moment there is a remittance, the obligation to deduct tax at source arises. Number 2, whether merely on account of such remittance to the non-resident abroad by an Indian company per se, could it be said that income chargeable to tax under the IT Act arises in India? Appellants are the distributors of imported, prepackaged, shrink-wrapped, standardized software from Microsoft and other suppliers outside India. During the relevant assessment years, appellant made payments to the said software suppliers, which, according to the appellants, represented the purchase price of the above-mentioned software. The ITO TDS held that since the sale of software included a license to use the same, payments made by the appellants to the foreign suppliers constituted royalty, which was deemed to accrue or arise in India. Therefore, tax at source was liable to be deducted under Section 195 of the Act. The said finding of the ITO TDS was upheld by the CIT appeals. In second appeal, the tribunal, however, held that the amount paid by the appellant to the foreign software suppliers was not royalty and the same did not give rise to any income taxable in India, and therefore the appellant was not liable to deduct tax at source. The department hence appealed to the Karnataka High Court. Before the High Court, the department for the first time raised the contention that unless the payer makes an application to the ITO TDS under Section 195 subsection 2 and has obtained a permission for non-deduction of the tax at source, it was not permissible for the payer to contend that the payment made to the non-resident did not give rise to income taxable in India, and that therefore there was no need to deduct any tax at source. This argument of the department was accepted by the High Court, vide the impugned judgment for reaching this conclusion. The High Court placed strong reliance on the judgment of this court in Transmission Corporation of AP Ltd versus CIT 1999. Aggrieved by the said decision, the appellants has come to the court by way of civil appeals. Analysis of Section 195 and of course verbatim reading of Section 195. Subsection 1. Any person responsible for paying to a non-resident, not being a company, or to a foreign company, any interest, not being interest on securities, or any other sum chargeable under the provisions of this Act, not being income chargeable under the head salaries, shall at the time of credit of such income to the account of the payee, or at the time of payment thereof in cash, or by the issue of a check or draft, or by any other mode, whichever is earlier, deduct income tax thereon at the rates in force. Subsection 2. Where the person responsible for paying any such sum chargeable under this Act, other than interest on securities and salary, to a non-resident, considers that the whole of such sum would not be income chargeable in the case of the recipient, he may make an application to the assessing officer to determine by general or special order the appropriate proportion of such sum so chargeable, and upon such determination, tax shall be deducted under subsection 1 only on that proportion of the sum which is so chargeable. Subsection 3. Subject to the rules made under subsection 5, any person entitled to receive any interest or other sum on which income tax has to be deducted under subsection 1 may make an application in the prescribed form to the EO for the grant of a certificate authorizing him to receive such interest or other sum without deduction of tax under that subsection, and where any such certificate is granted, every person responsible for paying such interest or other sum to the person to whom such certificate is granted shall, so long as the certificate is in force, make payment of such interest or other sum without deducting tax thereon under subsection 1. Section 195 subsection 6 as inserted by Finance Act 2008 with effect from 1st April 2008. 195 subsection 6. The person referred to in subsection 1 shall furnish the information relating to payment of any sum in such form and manner as may be prescribed by the board. Under section 195 subsection 1, the tax has to be deducted at source from interest other than interest on securities or any other sum not being salaries chargeable under the IT Act in the case of non-residents only and not in the case of residents. Failure to deduct the tax under this section may disentitle the payer to any allowance apart from prosecution under section 276B. Thus, section 195 imposes a statutory obligation on any person responsible for paying to a non-resident any interest not being interest on securities or any other sum not being dividend chargeable under the provisions of the IT Act to deduct income tax at source in force unless he is liable to pay income tax thereon as agent. 3. Payment to non-residents by way of royalty and payment for technical services rendered in India are common examples of sums chargeable under the provisions of the IT Act to which the aforestated requirement of TDS applies. The tax so collected and deducted is required to be paid to the credit of central government in terms of section 200 of the IT Act, read with Rule 30 of the Income Tax Rules 1962. Failure to deduct tax or failure to pay tax would also render a person liable to penalty under section 201, read with section 221 of the IT Act. In addition, he would also be liable under section 201 subsection 1A to pay simple interest at 12% per annum on the amount of such tax from the date on which such tax was deductible to the date on which such tax is actually paid. So in these provisions to the current section 195 provisions, there may be minor changes in the words. This section we are reading from the perspective of the assessment year for which section 195 was there. Later there has been minor amendments, so the listeners have to carefully go through section 195 provisions from the IT Act. The purpose of reading section 195 for this case law is to purely have this case law into perspective. So when you are looking at section 195 as of now, don't forget to open the income tax book and read section 195 independent of what we are doing now. The most important expression in section 195 subsection 1 consists of the words chargeable under the provisions of the Act. A person paying interest or any other sum to a non-resident is not liable to deduct tax if such sum is not chargeable to tax under the IT Act. For instance, where there is no obligation on the part of the payer and no right to receive the sum by the recipient, and that the payment does not arise out of any contract or obligation between the payer and the recipient, but is made voluntarily, such payments cannot be regarded as income under the IT Act. It may be noted that section 195 contemplates not merely amounts, the whole of which are pure income payments. It also covers composite payments which has an element of income embedded or incorporated in them. Thus, when an amount is payable to a non-resident, the payer is under an obligation to deduct tax at source in respect of such composite payments. The obligation to deduct tax at source is, however, limited to the appropriate proportion of income chargeable under the Act, forming part of the gross sum of money payable to the non-resident. This obligation, being limited to the appropriate proportion of income, flows from the words used in section 195 subsection 1, namely, within quotations, chargeable under the provisions of the Act. It is for this reason that White Circular number 728 dated 30th October 1995, the CBDT has clarified that the tax deductor can take into consideration the effect of DTAA in respect of payment of royalties and technical fees while deducting tax at source. It may also be noted that section 195 subsection 1 is in identical terms with section 18 subsection 3b of the 1922 Act. In CIT versus Cooper Engineering Limited, it was pointed out that if the payment made by the resident to the non-resident was an amount which was not chargeable to tax in India, then no tax is deductible at source, even though the assessee had not made an application under section 18 subsection 3b. Now it is section 195 subsection 2 of the IT Act. The application of section 195 subsection 2 presupposes that the person responsible for making the payment to the non-resident is in no doubt that tax is payable in respect of some part of the amount to be remitted to a non-resident, but is not sure as to what should be the portion so taxable, or is not sure as to the amount of tax to be deducted. In such a situation, he is required to make an application to the ITO TDS for determining the amount. It is only when these conditions are satisfied and an application is made to the ITO TDS that the question of making an order under section 195 subsection 2 will arise. In fact, at one point of time, there was a provision in the IT Act to obtain an NOC from the department that no tax was due. That certificate was required to be given to RBI for making remittance. It was held in the case of Czechoslovak Ocean Shipping International Joint Stock versus ITO by the Calcutta High Court in 1970 that an application for NOC cannot be said to be an application under section 195 subsection 2 of the IT Act. While deciding the scope of section 195 subsection 2, it is important to note that the tax which is required to be deducted at source is deductible only out of the chargeable sum. This is the underlying principle of section 195. Hence, apart from section 9 subsection 1, the other sections subsection 4, 5, section 4, section 5, section 9, section 90, section 91, as well as the provisions of DTAA are also relevant. While applying TDS provisions, reference to the ITO TDS under section 195 subsection 2 or 195.3 either by the non-resident or by the resident payer is to avoid any future hassles for both resident as well as non-resident. In the view of the court, subsection 2 of section 195 and subsection 3 of section 195 are safeguards. The said provisions are of practical importance. This reasoning of the court is based on the decision of the court in Transmission Corporation, in which the court has observed that the provision of section 195 subsection 2 is a safeguard. From this it follows that where a person responsible for deduction is fairly certain, then he can make his own determination as to whether the tax was deductible at source, and if so, what should be the amount thereof. Let us examine submissions and findings thereon. If the contention of the department that the moment there is remittance, the obligation to deduct tax at source arises is to be accepted, then we are obliterating the words chargeable under the provisions of the Act in section 195 subsection 1. The said expression in section 195 subsection 1 shows that the remittance has got to be of a trading receipt, the whole or part of which is liable to tax in India. The payer is bound to deduct tax at source only if the tax is assessable in India. If tax is not so assessable, there is no question of tax at source being deducted. This can also be seen in the case of Vijay Ship Breaking Corporation versus CIT, held by Supreme Court in 2008. One more aspect needs to be highlighted. Section 195 falls in Chapter 17, which deals with collection and recovery. Chapter 17b deals with deduction at source by the payer. On analysis of various provisions of Chapter 17, one finds use of different expressions. However, the expression sum chargeable under the provisions of the Act is used only in Section 195. For example, Section 194C casts an obligation to deduct tax at source in respect of any sum paid to any resident. Similarly, in Sections 194E and 194F, inter alia, provide for deduction of tax in respect of any amount referred to in the specified provisions. In none of the provisions, we find the expression sum chargeable under the provisions of the Act, which, as stated above, is an expression used only in Section 195 subsection 1. Therefore, this court is required to give meaning and effect to the said expression. It follows, therefore, that the obligation to deduct tax at source arises only when there is a sum chargeable under the Act. Section 195 subsection 2 is not merely a provision to provide information to the ITO TDS. It is a provision requiring tax to be deducted at source to be paid to the revenue by the payer who makes payment to a non-resident. Therefore, Section 195 has to be read in conformity with the charging provisions, that is, Sections 4, 5 and 9. This reasoning flows from the words sum chargeable under the provisions of the Act in Section 195 subsection 1. The fact that the revenue has not obtained any information per se cannot be a ground to construe Section 195 widely so as to require deduction of tax at source, even in a case where an amount paid is not chargeable to tax in India at all. We cannot read Section 195 as suggested by the department, namely that the moment there is remittance, the obligation to deduct tax at source arises. If we were to accept such a contention, it would mean that on mere payment, income would be said to accrue or arise in India. Therefore, as stated earlier, if the contention of the department was accepted, it was mean obliteration of the expression sum chargeable under the provisions of the Act from Section 195 subsection 1. While interpreting a section, one has to give weightage to every word used in that section. While interpreting the provisions of the IT Act, one cannot read the charging sections of that Act dehorse the machinery sections. The Act is to be read as an integrated code. Section 195 appears in Chapter 17, which deals with collection and recovery. As held in the case of Eli Lilly and Company India Private Limited by Supreme Court in 2009, the provisions for deduction of tax at source, which is in Chapter 17, dealing with collection of taxes, and the charging provisions of the IT Act, form one single integral inseparable code, and therefore the provisions relating to TDS applies only to those sums which are chargeable to tax under the IT Act. It is true that the judgment in Eli Lilly was confined to Section 192 of the IT Act. However, there is some similarity between the two. If one looks at Section 192, one finds that it imposes statutory obligation on the payer to deduct tax at source when he pays only income chargeable under the head salaries. Similarly, Section 195 imposes a statutory obligation on any person responsible for paying to a non-resident any sum chargeable under the provisions of the Act, which expression as stated above do not find place in other sections of Chapter 17. It is in this sense that we hold that the IT Act constitutes one single integral inseparable code. Hence, the provisions relating to TDS applies only to those sums which are chargeable to tax under the IT Act. If the contention of the department that the entire basis of the department contention is based on administrative convenience in support of its interpretation. According to the department, huge seepage of revenue can take place if persons making payments to non-residents are free to deduct tax at source or not to deduct tax at source. It is the case of the department that Section 195 subsection 2 as interpreted by the High Court would plug the loophole as the said interpretation requires the payer to make a declaration before the ITO TDS of payments made to non-residents. In other words, according to the department, Section 195 subsection 2 is a provision by which payer is required to inform the department of the remittances he makes to the non-residents, by which the department is able to keep track of the remittances being made to non-residents outside India. Supreme Court finds no merit in these contentions. As stated earlier, Section 195 subsection 1 uses the expression within quotation sum chargeable under the provisions of the Act. We need to give weightage to those words. Further, Section 195 uses the word payer and not the word assessee. The payer is not an assessee. The payer becomes an assessee in default only when he fails to fulfill the statutory obligation under Section 195 subsection 1. If the payment does not contain the element of income, the payer cannot be made liable. He cannot be declared to be an assessee in default. The above mentioned contention of the department is based on an apprehension which is ill-founded. The payer is also an assessee under the ordinary provisions of the IT Act. When the payer remits an amount to a non-resident out of India, he claims deduction or allowances under the IT Act for the said sum as an expenditure. Under Section 40, Clause A, Subclause 1, inserted White Finance Act 1988 with effect from 1st April 89, payment in respect of royalty, fees for technical services, or other sums chargeable under the IT Act would not get the benefit of deduction if the assessee fails to deduct tax at source in respect of payments outside India which are chargeable under the IT Act. This provision ensures effective compliance of Section 195 of the IT Act relating to TDS in respect of payments outside India, in respect of royalties, fees, or other sums chargeable under the IT Act. In a given case where the payer is an assessee, he will definitely claim deduction under the IT Act for such a remittance, and on inquiry, if the AO finds that the sums remitted outside India comes within the definition of royalty or fees for technical service or other sums chargeable under the IT Act, then it would be open to the AO to disallow such claim for deduction. Similarly, White Finance Act 2008 with effect from 1st April 2008, subsection 6 has been inserted in Section 195, which requires the payer to furnish information relating to payment of any sum in such form and manner as may be prescribed by the board. This provision is brought into force only on 1st April 2008. It will not apply for the period with which we are concerned in these cases before us. Therefore, in the view of the court, there are adequate safeguards in the Act which would prevent revenue leakage. Supreme Court analyzed applicability of the judgment in the case of Transmission Corporation. In Transmission Corporation case, a non-resident had entered into a composite contract with the resident party making the payments. The said composite contract not only comprised supply of plant, machinery and equipment in India, but also comprised the installation and commissioning of the same in India. It was admitted that the erection and commissioning of plant and machinery in India gave rise to income taxable in India. It was therefore clear even to the payer that payments required to be made by him to the non-resident included an element of income which was exigible to tax in India. The only issue raised in that case was whether TDS was applicable only to pure income payments and not to composite payments which had an element of income embedded or incorporated in them. The controversy before the Supreme Court in this batch of cases is therefore quite different. In Transmission Corporation case, it was held that tax at source was liable to be deducted by the payer on the gross amount if such payment included in it an amount which was exigible to tax in India. It was held that if the payer wanted to deduct tax at source not on the gross amount but on the lesser amount on the footing that only a portion of the payment made represented income chargeable to tax in India, then it was necessary for him to make an application under section 195 subsection 2 of the Act to the ITO TDS and obtain his permission for deducting tax at source at lesser amount. Thus, it was held by the Supreme Court that if the payer had a doubt as to the amount to be deducted as tax at source, he could approach the ITO TDS to compute the amount which was liable to be deducted at source. In the view of the Supreme Court, section 195 subsection 2 is based on the principle of proportionality. The said subsection gets attracted only in cases where the payment made is a composite payment in which a certain proportion of payment has an element of income chargeable to tax in India. It is in this context that the Supreme Court stated, if no such application is filed, the income tax on such sum is to be deducted, and it is the statutory obligation of the person responsible for paying such sum to deduct tax thereon before making payment. He has to discharge the obligation to TDS. If one reads the observation of the Supreme Court, the words such sum clearly indicate that the observation refers to a case of composite payment where the payer has a doubt regarding the inclusion of an amount in such payment which is exigible to tax in India. In the view of the court, the above observations of this court in Transmission Corporation case, which is put in italics, has been completely, with respect, misunderstood by the Karnataka High Court to mean that it is not open for the payer to contend that if the amount paid by him to the non-resident is not at all chargeable to tax in India, then no taxes at source is required to be deducted from such payment. This interpretation of the High Court completely loses sight of the plain words of section 195 subsection 1, which in clear terms lays down that tax at source is deductible only from sums chargeable under the provisions of the IT Act. That is, chargeable under sections 4, 5 and 9 of the IT Act. Before concluding, the Supreme Court said it can clarify that in the present case on the facts, the ITO TDS had taken the view that since the sale of the concerned software included a license to use the same, the payment made by appellant to foreign suppliers constituted royalty which was deemed to accrue or arise in India, and therefore tax at source was liable to be deducted under section 195 subsection 1 of the Act. The said finding of the ITO TDS was upheld by the CIT appeals. However, in second appeal, the tribunal held that such sum paid by appellant to the foreign software supplier was not a royalty, and that the same did not give rise to any income taxable in India, and therefore the appellant was not liable to deduct tax at source. However, the High Court did not go into the merits of the case, and it went straight to conclude that the moment there is remittance, an obligation to deduct tax at source arises. which view stands hereby overruled by the Supreme Court. Since the High Court did not go into the merits of the case on the question of payment of royalty, Supreme Court hereby set aside the impugned judgments of the High Court and remit these cases to the High Court for de novo consideration of the cases on merits. The question which the High Court will answer is whether, on facts and circumstances of the case, the tribunal was justified in holding that the amounts paid by the appellants to the foreign software suppliers was not royalty and that the same did not give rise to any income taxable in India, and therefore the appellant was not liable to deduct any tax at source? Question mark. Subject to what is stated herein above, Supreme Court set aside the impugned judgments and remit these cases to the High Court to answer the question framed herein above. Accordingly, the appeals filed by the appellants stands allowed with no order as to costs. So with this, in this case, G India won the case, and along with G India there were other cases that were taken up for hearing together by the Supreme Court, which included Sonata Software also. So in these cases, detailed examination of section 195 was made, and a clear distinction was made by the Supreme Court that when it comes to transmission corporation, there was a clear intention that the Supreme Court was more concentrating on section 195 subsection 2, which allows determination of income in the gross payment, and that was a case of composite payments. In a cases where there is clear income, section 195 subsection 2 does not arise, say 195(3) can arise, or directly 195 subsection 1 can be taken into consideration. And the most important takeaway from this judgment is, within quotations, chargeable to tax under the IT Act. If this chargeability under section 4, 5, 9, 90, 91 and the tax treaty is not satisfied, then income is not chargeable to tax in India. Effectively, withholding of tax need not be done in India on such payments. Thank you for a patient hearing. In order to get more such videos, kindly subscribe this channel and click on bell button to receive new videos in real time. Please like the video in order to encourage to make more such videos.